Good afternoon, everyone. I'm so glad that you're all here. My name is Andrea Gillespie. I'm the director of the James Weldon Johnson Institute. And on behalf of the staff and the visiting fellows of JWJI, I'd like to welcome you today to today's Race and Difference Colloquium session. Today, we're pleased to have Professor Alejandro de la Fuente from Harvard University with us. Dr. de la Fuente is the Robert Wood Bliss Professor of Latin American History and Economics and Professor of African and African American Studies at Harvard. He is the founding director of the Afro-Latin American Research Institute at the Hutchins Center for African and African American Research. A historian of Latin America and the Caribbean who specializes in the study of comparative slavery and race relations, Professor de la Fuente's works on race, slavery, law, art, and Atlantic history have been published in Spanish, English, Portuguese, Italian, German, and French. Today he's going to be speaking of his most recent book called Becoming Free, Becoming Black, Race, Freedom, and Law in Cuba, Virginia, and Louisiana, which he co-authored with Ariela Gross. He's also the author of Havana and the Atlantic in the 16th Century and of A Nation for All, Race, Inequality, and Politics in 20th Century Cuba. He is the co-editor, along with George Reed Andrews, of Afro-Latin American Studies, An Introduction, and of the Afro-Latin America book series at Cambridge University Press. Dr. de la Fuente is also the curator of 3 art exhibits dealing with issues of race and the author or editor of their corresponding volumes, Queloides, Race and Racism in Cuban Contemporary Art, Drapetomania, Grupo Antiano, and the Art of Afro-Cuba, and Diago, the Past of this Afro-Cuban Present. So without further ado, please join me in welcoming Dr. Alejandro de la Fuente.
Well, many thanks to Professor Andrea Gillespie, to Assistant Director Rhonda Patrick, and to all the staff of the James Weldon Johnson Institute at Emory University for the opportunity to return virtually to Emory and to share with you the results, some ideas, and basic arguments of the recent book that I have written with my colleague and collaborator, Professor Ariela Gross from University of Southern California, who is a well-known specialist of the legal history of race and slavery in the U.S. As Professor Gillespie said before, I'm a Latin Americanist, so this book is a collaboration of scholars who share similar interests, but who specialize on different areas of the world. And it is a book that offers or tries to offer a new look and new answers to an old question about the development of racial regimes in the Americas between the 16th century and the 19th centuries, a period marked, as you know, by the enslavement of Africans and people of African descent across the Americas. It is the question that guided previous generations of comparativists, people like Frank Tannenbaum, Stanley Elkins, Herbert Klein, Carl Degler, Harry Hutton, and kind of a literature that then, questions that then lived on in the comparative literature of the US and South Africa, the works of people like Stanley Greenberg, John Sell, George Frederickson, and Anthony Marks. The most recent and remarkable effort in this literature is Robert Cottrell's book, The Long Lingering Shadow. Our starting point, however, is very different from those of previous authors, and that is in part because we are beneficiaries and have participated in a sort of a historiographic boom in the last few decades concerning race, slavery, and the law in the Americas. These studies, in which both Ariela and I have participated, favor the analysis of slavery and race in the law, not through the certitude or the alleged certitude of any written texts, but as spaces of conflict where different interests, interpretations, and visions struggled to gain legitimacy and official sanction. Or to put it another way, our comparative effort is anchored in the boom in the legal cultural historiography of slavery from below. Now, we chose 3 locations for our study. 2 of them, Cuba, Louisiana, and Virginia, as you know, have been used as proxies for for Spanish and British colonialism before this were the subject of a famous comparative study by Herbert Klein. And to that, we added the case of Louisiana, which gave us an opportunity to study a hybrid society that moved across jurisdictions across time. You know, it was first French, it was then Spanish, and then ended up being American. Now, our analysis is based on a founding similarity. In all these three societies, we find basically a similar impulse to use local law to cement the association between African origin and enslavement, linking Blackness with social degradation. By the early 18th century, the legal regimes in all three jurisdictions constituted Blackness as a degraded social category that was basically inseparable from enslavement. Despite these similar beginnings, however, by the mid-19th century, the social implications of Blackness in each of these regions were fundamentally different. A free man of color in 1850s Cuba could marry a white woman, could attend public schools, and could participate in religious associations that gave him some opportunities to participate in public life. In Louisiana and Virginia, meanwhile, free people of color saw their churches and their schools closed, faced criminal prosecution for marrying or trying to marry across the color line, and risked being kidnapped, imprisoned, expelled, and even re-enslaved for staying in the state in which they were born. In Louisiana and Virginia, the presumption that civic acts could only be performed by whites was so strong that they were used by people of color to prove that they were not Black. Citizenship was strictly associated with whiteness and was incompatible with African origin. In Cuba, the free population of color faced legal limitations, and I'll speak to some of those later. But the process of racializing civic acts as something exclusively white did not advance to the same extent. So why? Why this divergence that starts with common origins? That's basically the central question that our book seeks to answer. Now, to us, the key to these divergent trajectories of racial differentiation was not the law of slavery, which has attracted the attention of almost all previous scholars, beginning with Tannenbaum's famous contrast between an Anglo-Saxon system of slavery and an Iberian or Latin American system of slavery. To us, the most important legal spaces were not those of slavery, but the law of freedom, which was used as a crucial space for the creation of racial regimes for race-making purposes. Laws regulating freedom and manumission determined to start whether it was possible to transit from enslavement to freedom, from enslaved status to free status. But this was only the first step. The laws regulating the lives and institutions of free people of color created the boundaries between Blackness and whiteness, reserved rights only for whites, and reserved specific degradations only for people of African descent, the so-called Blacks. Therefore, our book challenges the traditional vision of a contrast between slave systems in Latin America that supposedly recognized enslaved people as persons versus a British system that allegedly treated them only as things. In our history, what really matters to us is the development of racist legal regimes, the connection between whiteness and citizenship on the one hand, Blackness and slavery on the other hand, and the impossibility of citizenship, in some cases even freedom, for people described as Blacks. Now, this divergence did begin in some ways with legal traditions, the way people like Frank Tannenbaum argued years ago, in the sense that the right to manumission was firmly rooted in the Iberian legal world of slavery. But to us, the fundamental thing is that in the Iberian world, manumission manumission was not linked to the construction of a racial order. Manumission was not tied to race making. In the Iberian world, manumission was linked to the practice of ransoming Christian or Muslim captives and was conceived as a transaction with pious and religious implications that applied to people of many different origins, including those from the Eastern Mediterranean, who would later be described as white slaves. This is a key difference with Louisiana and Virginia, where the regulation of manumission became part from the very beginning of a racial order that identified freedom with whiteness and slavery with blackness. In other words, if you really want to create a perfect world of enslaved blacks and free whites, you need to, in fact, limit manumission. You need to limit the possibility of transitioning from one status to the other. You need to make sure that the very possibility of black freedom becomes legally impossible. In the case of the Iberian colonies, that possibility existed only because it was not tied to racial concerns or race-making purposes. In any case, legal traditions are an important reference point, but the story did not end there. The creation of race as a category of difference through the law was a long process with many unpredictable twists and turns, not a linear progression. We cannot move from 16th century or 15th century precedents to 19th century outcomes. Virginia was in some ways in the 17th century a more open and fluid society than Cuba, yet by the 18th century, it had created significant legal obstacles to manumission. New Orleans was a mecca for free people of color in the early 19th century in the US South, as many of you know, yet it became a hugely hostile place for them in the mid-19th century. So unlike many, if not most, previous comparative studies, we tried to pay very careful attention to temporary changes and to how these legal regimes on race and freedom evolved over time. So let me, again, share my screen with you here. That's why we divide our study in basically three fundamental periods. A first period, which is something of a foundational period that covers from the origin of colonization through the mid-18th century. A second moment, and that chapters 1 and 2 correspond to that first period. A second moment, which is chapter 3, which corresponds to the age of revolution, roughly between 1760 and 1830. It is a period that includes not only the American Revolution, the American independence, and the Haitian Revolution, with all its consequences and reverberations, but that in our study extends through the 1820s to include the movements for independence in Latin America. And finally, a period of kind of maturation and consolidation of racial orders between the 1830s and the 1860s, before the wars that took place in each of these territories, wars that in all cases were very much related, as you know, to slavery, the Civil War in the US and the so-called 10 Years' War, or War of Independence of Cuba, which began in 1868. Now, the early period is marked by a fundamental similarity. In all jurisdictions, as I said before, legislators made a systematic effort to associate blackness with slavery, with enslavement, to link blacks, negros, Negroes, noirs with social degradation. The slave societies of the Atlantic built race as a category of difference through the law, converting Africans who came, of course, from many diverse linguistic families and cultures into blacks, into Negros, into noirs, into Negroes, subjects without history, without genealogy, without honor, erasing and compressing in the process a multitude of cultures, languages, histories, and experiences into a single category of, legal category of degradation, Negro, Negro, Noir. This is a process, if you think about it, of unparalleled epistemic violence. All that richness, all that diversity that is lost under this new legal label, legal category. The legal prohibitions that apply to all Black men and women, free or enslaved alike, or that define certain actions of any Black free or enslaved against whites as a crime, help to define degradation in racial terms rather than in terms of enslavement. For the purposes of that legislation, the important distinction was not between slave and free, it was between white and Black. Across the Americas, slave owners began this process of racial construction in the law almost as soon as they arrived in the colonies. But it's interesting to note that on this front, the Iberians traditions worked to facilitate the creation of racial orders and of racist legal orders, because by the early 16th century, the Iberians have already advanced, have already taken significant steps to associate Blackness, sub-Saharan Africans with enslavement, especially in Mediterranean Spain, in places, Iberia, in places like Lisbon, Seville, Valencia. This association had already gained some traction in local legislation in these areas. It's interesting that the very first regulation that we have about slavery in the New World, a group of ordinances approved by the Town Council of Santo Domingo in Española in 1522, very early as you can see, is called Ordenanzas de los Negros, ordinances of the Blacks. It's not called ordinances of the slaves. The local authorities of Havana could build on these precedents to then create in legal law, to then constitute Blackness as a degraded category in law from the very beginning. In the first quarter of the 18th century, however, by the first quarter of the 18th century, we do see a first important divergence between Cuba on the one hand and Virginia and Louisiana on the other hand. In both Virginia and Louisiana, the owner's right to grant manumission, to grant freedom to a slave, and manumission was a slave owner right, not a slave right. And therefore, the possibility, the right, or the possibility of an enslaved person to claim freedom was severely restricted, both in Virginia and Louisiana. The French included restrictions on manumission in the Code Noir of 1724. And in Virginia, restrictions on manumission began in 1691 and were effectively codified in 1723. In both Virginia and Louisiana, for a manumission to be effective, it required approval of colonial authorities. This never happened in Cuba, where manumission remained a private institution that was not linked to the creation of a racial order, but to traditional understandings and practices of slave ownership. Now, this is not to say that enslaved people in Louisiana and Virginia did not try, in fact, to obtain freedom. But the number of people who managed to do so during the 18th century was extraordinarily small. Our archival work in this sense confirms what previous historians had already established, which is that the numbers of people who managed to escape from enslavement in Virginia and Louisiana were extremely small during the 18th century. As you can see on the table, whereas in Havana, about 15% of the total population was composed by people of color. In Virginia, it was less than 1%, about 3% in New Orleans. Of course, all these figures are simply indicative. They have to be taken with some reservation, but they do reflect fundamental social differences across these jurisdictions as early as the 1760s or 1770s. Or to put it differently, these jurisdictions arrived to the age of revolution in fairly different fairly different conditions. Now, we always think about the Age of Revolution as a period in which, especially under the influence of Haiti, opportunities for freedom, even the possibility of the end of slavery becomes part of the political landscape. And in a sense, we do see a growth of the population, free population of color across all jurisdictions, although demands for manumission and freedom in this period were as much a result of revolution as of reaction and reform. Because terrified by the example of Haiti, slave regimes responded with various legal measures that were basically measures of containment and reform. But those measures frequently did create opportunities for enslaved people to claim their own freedom and to escape from slavery. For instance, in Virginia, a ban on the importation of slaves from neighboring countries, from neighboring territories, was later used by many slaves to claim that they had been illegally imported into Virginia, and therefore to claim freedom on that basis, something that was not part of the original intent of the law. A law of 1782 increased significantly opportunities for manumission in the state, in Virginia, because it removed the need for official approval. Therefore, it was after 1782, a slave owner in Virginia could grant manumission to a slave, just like a private slave owner could do in Cuba, or by that time also in Spanish Louisiana. For a time then, it looked like the free populations of color, that the communities of free people of color in places like Virginia and Louisiana would grow and would follow a path similar to that of Havana, that these communities would achieve what Kimberly Hanger has called a critical mass, would become large enough that they could no longer be eliminated or reduced in significant terms. Of course, in all three cases, the growth of the population of color significantly complicated, and you can see in this table how, even though the free population of color of Virginia was still very small, let's say by 1810, there is a significant growth. It's spectacular growth between 1770 and 1810. You can also see that in New Orleans, this is not all of Louisiana, this is only New Orleans, the proportion of free people of color also increased, had increased significantly by the time of the first census in 1800. And of course, in all these cases, the very existence of these communities complicated significantly the association between Blackness and slavery that lawmakers had tried to enshrine in law since the early colonial period, prompting new anxieties about race and status. But there is a crucial distinction. In Cuba and in Spanish Louisiana, manumission and the very existence of free people of color were linked to traditional and time-honored practices enslaving, to notions of Blacks as royal subjects and vassals of the king. Manumission was an institution of the ancien regime. Manumission was not an institution linked to the revolutionary Atlantic. By contrast, in Virginia, new regulations on manumission, like the law of 1782, and subsequent anxieties about the growing free population of color were linked from the outset to debates about general emancipation and Black citizenship. It's interesting that petitions, popular petitions of the time, petitions against the law, petitions that requested that the law of 1782 be abolished, referred to manumission as, I quote, partial emancipation, end of the quote. In other words, for the petitioners, manumission was not part of a normal functioning of slave societies. Manumission was a dangerous step towards Black freedom and Black citizenship. Haiti's meaning, the Haitian Revolution hovered over everybody. That example affected slave owners in Louisiana, in Cuba, and in Virginia. But the meanings of Black freedom were different according to each locale. The local archives of Richmond contain dozens of petitions, of popular petitions, to abrogate the Manumission Act of 1782. So under pressure in 1806, so not even 20 years later, the legislature did not prohibit manumissions, but provided that any slave who obtained freedom would have to leave the state after 6 months under penalty of re-enslavement, unless the manumitted slave obtained an official residence permit. This measure sought once again to build a social order in which Blacks were by definition slaves, and clearly suggested that free Blacks had no place literally in the new Republican society. In Louisiana, already under American control, a code of 1806 suspended Spanish legislation on slavery and reintroduced the requirement from the French period that any manumission would require official approval. Now, in Louisiana, we actually see how enslaved people basically deployed and invoked Spanish legislation well into the 1830s and 1840s, but the balance of forces had changed with these new laws. We identify a turning point basically in the 1830s, and that explains the chronology of our study. A new start in the divergent trajectories concerning race race making in these societies. In 1829, David Walker, a free colored man, published Appeal to the Colored Citizens of the World, an incendiary call to the world citizens to do justice, warning white slave owners that their end would be tragic and immediate. This is basically a vision that what had happened in Haiti could happen elsewhere. And 2 years later, the Nat Turner Rebellion, which resulted in the death of over 50 white people in Virginia, seemed in fact to fulfill Walker's prophecies. Alarms of slave rebellions sounded all over the South and found echoes, this is very interesting, in the newspapers of New Orleans, which were typically quite reluctant to publish anything dealing with slavery or with slave resistance. In Cuba, colonial authorities recorded more than 20 slave rebellions between 1812, the year of the famous Aponte conspiracy, and 1844, the year of La Escalera, the ladder, a vast conspiracy involving rural and urban slaves, as well as free people of color from Matanzas to Havana. So the confluence of abolitionism, slave rebellions, and a growing population, free population of color, led slave owners to fear alliances between slaves and free Blacks, such as those that actually did take place with La Escalera in Cuba. And it was in this context that proposals for so-called colonization plans, through which free Blacks would be removed and sent to remote territories, preferably in Africa, took hold. Virginia planters represented the core of the American Colonization Society, whose fundamental goal, as you know, was to eliminate the existence of free Blacks in the state, was to basically export and deport free people of color from the state. As a popular petition signed by 96 citizens from Northampton County, Virginia, needless to say, when I say citizens, that means whites, stated in 1825, free Blacks, I quote, are inferior in intelligence and formation to whites, degraded by the stain of their color, excluded from all civil rights held by the most humble white man, and excluded from any participation in government, end of the quote. In other words, for people who were so outside the political and social order, there was no place. The place was either enslavement or deportation. They should be expelled. The year 1831 marked the beginning of a legal onslaught against free people of color. In addition to efforts to remove and send them to Africa, new provisions established restrictions of movement, on their right to remain in their place of origin, and even on their property rights. In Virginia, a new provision of 1832 reiterated the prohibition of 1806 and ordered that free people of color leave the state after manumission. Although many managed to remain, they did so illegally, the law introduced a very powerful uncertainty into the lives of free people of color, given that their residency was precarious and relied on the sponsorship and complicity of whites for their safety. I mean, this was a very precarious freedom. The archives of Virginia are filled with requests to remain in the state. Between 1830 and 1860, we found and we studied 124 cases of proceedings against illegal Black residents in Virginia. In New Orleans, a law of 1830 required a $1,000 bond for any manumission to ensure that free people, that those who were manumitted would not remain in the state unless they obtained an official license. From 1852 onwards, a manumission could only take place if it was accompanied by a ticket to Liberia. In other words, if the person who was receiving the manumission would leave Louisiana and emigrate to Liberia. The number of free people of color who tried to regularize their residence during the 1850s grew exponentially in New Orleans. There is no record, we didn't find any records of petitions for residents to regularize residence from free people of color in 1852 or 1853. We found 11 in 1854, 43 in 1855, 238 in 1856. By 1859, the number had grown to 420. This is from 11 in 1854 to over 400 in 1859. The number of unlawful residency arrests against free people of color in New Orleans grew from about 10 per month in 1851 to nearly 100 per month by 1859. This is an assault on the most basic right of all, the right to a homeland, the right to residence in your place of birth. In a supreme legislative effort to perfect the association between Blackness and slavery, both Virginia and Louisiana passed voluntary, quote unquote, re-enslavement laws in the 1850s. And in both states, there are examples of free people of color who used this legislation so that they could remain in their state and so that they could remain close to their families and to their loved ones. At the same time, steps were taken to eliminate manumissions altogether, once and for all. The Constitution of the State of Virginia in 1851 proclaimed that the General Assembly would not approve any additional manumission in the future. And in Louisiana, a law of 1857 declared manumissions of any kind illegal. The free community, the community of free people of color of New Orleans, which had been the largest in the American South during much of the 19th century, collapsed socially and demographically in the 1850s. Let me quickly go back here to the figures so that you can see what we're talking about. By 1860, this community was a shadow of its former self. Now, the free population of color suffered illegal assault also in Cuba, particularly after the conspiracy of La Escalera that I mentioned before in 1844, but not with the intensity experienced in Virginia and Louisiana. I think the clearest example of this assault was the temporary, only temporary, however, dismemberment of the militia battalions of Pardos and Morenos, of Blacks and Mulattoes. one of the most important institutional platforms of the free population of color and the community of free people of color through since colonial times, since early colonial times. But free Blacks residing in Havana or the rest of the island did not have to fight, for example, for the basic right to live in their home territories, nor did they face the prospect of mass deportations. Now, there were racist ideologues in Cuba, like Jose Antonio Sacco, who proposed that in order to obtain freedom, Blacks should leave the island, basically what Virginia and Louisiana already mandated, but such proposals never became law, nor were legal steps to restrict manumissions taken. At the same time, it is important to note that in absolute terms, Havana's free population of color remained basically stationary between the 1840s and the 1860s, probably an expression of the repression that this community experienced after Las Caleras, including deportations of people who were involved in that conspiracy. Given the increasingly perfect association between freedom and whiteness in Virginia and Louisiana, between enslavement and Blackness, the demands for freedom in these territories frequently took the forms of claims of racial identity. In other words, in order to escape from slavery, in order to claim freedom, the most effective legal argument was to claim that someone was not legally Black. And we find many cases in which plaintiffs would argue that they descended from women of indigenous background. We also found a series of petitions in the archives filed by people of ambiguous racial identity who sought to use the law to obtain legal statements that certified that they were not Negroes, quote unquote, that they were not Blacks, therefore avoiding the legal limitations suffered by free people of color. These trials, these petitions, these Negro petitions and the processes that they produced, in fact, helped to consolidate citizenship as something available only to whites, since they were based on the notion that the only way to access freedom and to access standing and status was through the denial of Black ancestry. Now, similar processes on racial identity also took place in Cuba during the 19th century, but in a very different context. These trials on these conflicts over racial identity basically took place in the so-called unequal marriages, which invariably involve dealing with the racial backgrounds of the spouses. The very idea of unequal marriage implied that there are people of different racial backgrounds who are trying to formalize the sacrament of marriage. But there are, of course, two differences to highlight here. The first, and perhaps the most obvious one, is that such marriages were possible, whereas they were legally impossible in Virginia and Louisiana since the early colonial period. Second, in these processes, in these legal processes concerning unequal marriages, those seeking dispensation and approval to enter racially mixed marriages downplayed or minimized the importance of racial difference by highlighting other indicators of difference and social worth, such as honor, education, decency, economic status, or legitimacy of origin. That is, these legal processes constituted Blackness as a stain. That's what made the marriages unequal to begin with, but not as a condition that was inexorably incompatible with other rights and attributes, with decency and with honor. Now, the white racist republicanism of Virginia and Louisiana did not have a parallel in Cuba, because there was no political need to exclude free Blacks from an egalitarian political and social order, such as the one that implied in a Republican context, as in the US. As Bob Cottrell has argued, the specter of Republican equality and Black citizenship fueled racist ideology and practices in the United States in a way that was not politically necessary in a society like Cuban colonial society, which did not operate under a presumption of equality. Free Blacks did not become equal citizens. Free Blacks entered into a highly hierarchical society where inequality was built in. Furthermore, as David Sartorius has pointed out, after the Constitution of Cadiz in 1812, many free people of color in Cuba identified with the imperial project as the best guarantee to their own rights as a community, not to any Republican dreams of equality and citizenship. So like Tannenbaum, and I'm going to conclude with this, and mid-century comparativists, in the 1860s, we see a great divergence between Cuba on the one hand, and Louisiana, and especially Virginia on the other. Not in the regimes of slavery. Plantation slavery was equally brutal in Louisiana, Cuba, and Virginia, but in terms of race and race-making in the law. A person enslaved in mid-19th century Cuba would encounter free people of color almost by definition, on a regular basis. They would encounter somebody of African descent who was free on a regular basis. This was neither exceptional nor remarkable. Such a possibility, however, was rare, even impossible in many areas of Virginia and Louisiana. This in turn helped to consolidate the link between Blackness and slavery, between whiteness and citizenship in the US. But we have charted a very different route. We chart a very different route to reach to this point of divergence, not only because our starting point is in fact a point of similarity. In all these jurisdictions, what we find is that slave owners and legislators went to great lengths to constitute Blackness as a degraded condition inseparable from slavery. The manumission regimes in Virginia and Louisiana were developed as part of these legal projects of race-making and racialization, something that did not happen in Cuba, where manumission was a traditional institution that was not linked at all to the creation of a racial order. And this would have, over time, dramatic consequences. The very existence of a free community of color was an obstacle to the creation of the very racial order that legislators and slave owners had tried to create, a racial order of enslaved Blacks versus free white citizens. As Supreme Court Justice Roger Taney said in Dred Scott's infamous decision, in the United States, the perpetual and impenetrable barrier was not between enslaved and free, it was between Blacks and whites. This barrier also existed in Cuba, of course, but it was neither perpetual. It was possible to escape from slavery through manumission and to access freedom, and it was not impenetrable, not in the way that Taney envisioned, and the unequal marriages are a good example of precisely how these boundaries were more permeable in the Cuban case. So laws regulating free people of color also probably served as platforms for post-emancipation societies seeking to maintain people of African descent in a subordinate social place. The laws regulating slavery were probably of limited use after emancipation, although this is an area where we think needs additional research. But in the transit from Black slave to Black citizen, the common and most important thread, we argue, was not from slave to citizen, the way that Tannenbaum claimed in his famous book. It was in fact from Black to Black. That's race is really what provides a continuity there that we can probably trace beyond emancipation in the 19th century and into the 20th and 21st centuries. And with that, I am going to pause so that we have time to hear any comments, suggestions, or questions that you may have. Thank you.
Great. Thank you so much, Dr. De La Fuente. We really, really appreciate it. Just as a reminder, if you look down at the bottom of your screen, you can type in questions in the Q&A function. If that's not working for you and you want to use the chat function, please feel free to include it there. I should be able to see it there. We do have one question, and I'll just ask questions as they come. So this first question is from our colleague, Michelle Gordon, who's a former JWJI fellow. So the first thing she wants me to tell you, and I thought of this during your talk as well, was that if you were here at Emory, we would take you upstairs to our Rose Library, our Rare Books Library, and show you W.B. Du Bois's first edition copy of David Walker's Appeal that has his own annotations in it. So it's always something that I'd love to show speakers and something that we're very proud of. So
well,
her question.
I want to come and see that at some point, okay?
We will. We'll try to make that happen. So her question is, how did these legal efforts during the slavery era to codify people of color as enslaved and white people as free prepare the grounds for post-emancipation legislatures to deny civil rights to people of African descent in Cuba or the U.S. South?
So it's a great question. It's a question with which we close the book. You know, we don't quite answer that question because that question would take us over across emancipation to follow on this in the late 19th century Reconstruction, the end of Reconstruction, and then 20th century and 21st century. So we don't do this in the book, but we do end up suggesting that that the massive differences that had been built into legal regimes concerning race, especially in the U.S. South, but not exclusively in the U.S. South, also in Cuba, although with different, with other peculiarities, that these distinctions probably were very useful and could be easily invoked after emancipation in order to create or recreate legal regimes that maintain people of African descent, or that try to maintain people of African descent at the bottom of society, or even outside the political order. I mean, all this really massive body of local law did not simply end, did not simply die after emancipation, and provided for continuities. That's why we think it's much more important to look at this body of law and not at as most scholars had done before, at slave regimes, because, you know, okay, so slavery did end, and of course one can argue that about that end too, but that provided a very clear kind of cutting moment, but that didn't apply at all to race and to race-making efforts in the law. So we haven't written that book, Michelle. I don't know if we will write it, but or if, you know, some other scholar will take it from there. But that's exactly where we end, and we think it's a very important and powerful question.
Thank you so much. So the next question is from Francine Allen, one of our fellows this year. She asks, you mentioned that in Cuba, some free Blacks said they were not Black to avoid legal limitations. Did this lead to passing becoming an important choice for some free Blacks who wished social inclusion and advancement?
So, in fact, Francine, the not a Negro certificates are from the U.S. South, are from Virginia. They're not even from LA, they're from Louisiana, they're from Virginia. We haven't found those in Cuba, because in Cuba, as these unequal marriages, these legal processes concerning unequal marriages, I hope show, it was possible to negotiate your race. There was more room to negotiate I mean, you could say, yes, I am Black, but I am educated and I come from a family of standing and decency and honorability. So Blackness, by making those arguments, you contest the traditional constitution of Blackness as just a category of debasement and subordination. you basically can infuse Blackness with other attributes, wealth, education, honorability, decency, that were simply impossible in the US South. So in places like Virginia, these people of ambiguous, what we have seen in these processes is that people go to try to get a certificate, that a document, a court-issued document that certifies that they are not, quote unquote, a Negro. And obviously, this is a document that then can be used to prove that that all the legal limitations that apply to people of African descent, to Blacks, do not apply to you, that you escape from that. Which, of course, is a rather graphic contrast with what you see with these unequal marriages in Cuba, where you can, in fact, debate. You're a Black but, it's not impossible to add something to that sentence. And bear in mind where the very possibility of intermarriage is legally possible. I mean, you still have to go through a process to explain why you want to do this, but it's not impossible for a man of African descent to marry a white woman, or more frequently for a white man to marry a woman of African descent. And these marriages are in fact not that rare. And on top of that, by the 1880s, even the need for a process is eliminated. So that again, we're talking about how race is constituted in these legal regimes. There you have a very, very powerful contrast. As you know, interracial marriage is illegal in Virginia. I mean, I'm going to quote this wrong, but maybe Andra knows the date. It's something like 1967 or something.
Somewhere in there.
I mean, yeah. This is like yesterday, okay? This is like yesterday. That's talking about how these distinctions in law live on after emancipation. There you go. There you have a pretty graphic example.
Great. Well, thank you so much. So the next two questions are from our fellow Barbara Combs. First question is, can you speak a little about the title of the book? I'm struck by how there are multiple interpretations of this title. I started thinking about the Sampson certificate and the claim, not a Negro, and it made me think of James Baldwin's claims that I'm not your Negro.
So the title Becoming Black, Becoming Free, it reflects our understanding that the really important story here, that the really important distinction is in the law of freedom and race-making efforts that are associated with the possible existence of free people of color. That what legislators do across jurisdictions, and I want to stress one more time the similarity of this effort. These jurisdictions start from rather similar beginnings on that front, is to equate Black, Negro in Spanish, Negro in English, Noir in French, with the basement. But Negro, Noir is constituted through these legal efforts. The very category is constructed through these efforts in the law. The law gives meaning, this negative and pejorative meaning. The people who boarded the slave ships in the African coasts were not Noirs, were not Negros. They were Yoruba speaking. They were speakers of Kimbundu or Kikongo or Mande, or these people came from many different cultures. These labels that the laws use and constitute since the early colonial period obliterate all that richness, obliterate all those stories, obliterate those genealogies, those communities, that linguistic variation. All that is compressed into a single label. So becoming Black is something that is a process, that itself is a process of enormous violence. And the legal regimes play a leading role in that process. Becoming free is, in a sense, at the very center of our book, because what we try, and I know that this maybe didn't come through in my presentation so much because of time, is that we try in every case to recover and to study changes across time through the initiatives of enslaved people and people of African descent, and how they use the law in order to improve their lives and to make claims, escape from slavery, protect their loved ones. So becoming free was also a process. Was not just a moment of transition from one status to the other. It was a very long, contested, contentious, and difficult process. And what we do, in a sense, in the book is to study how those struggles evolve over time in these three jurisdictions. I don't know if that answers your question, but I hope it does.
Thank you very, very much. The second question was, as you said, it did. The second question was, you did a great deal of work in the archives. Can you tell us about your approach? Were you looking to find support for a hypothesis you went in with, or just on a discovery project? And did anything surprise you?
Excellent question. Yes, we were surprised. We were going to write a very different book. We began the book, and you can probably imagine that doing a collaborative book like this has its own challenges, you know, and we can talk about that. It was almost funny how sometimes Ariela and I would spend a week on a paragraph. And at some point I would tell her, you know what, you win, we'll leave it the way you want. Enough, let's move on. But we were going to write a very different book. And it was a book comparing slave laws or regulations concerning slavery. We thought, following and building on the pre-existing scholarship, which is not small and which is, you know, it's of, you know, it's something of quality that we thought provided good intellectual arguments. We were going to write, using this kind of new scholarship on race and slavery from below, we were going to write a new comparative study of slave law in the Americas by using these three jurisdictions. And we discovered so that was our initial working argument and hypothesis. And we quickly discovered that really that was not the distinction. I mean, Cubans' plantation slavery was as brutal as Louisiana's slave plantations of the 19th century. I mean, we could not find any significant divergence there, quite the contrary. But that's not what, you see, when comparativists highlighted differences, they were actually not talking about slavery, they were talking about race. And then they would go and look into slavery in order to answer that. What we did, we began with the same assumption. We need to look at, you know, regulations concerning slavery. But along the way, during the research, and as we began to write about this and to think about this, we realized that what we really were writing about was about race and race making in the law, and how Black freedom, complicated these ideal constructions of these racist ideal constructions of societies composed only by free whites and enslaved Blacks. Every free person of color represented a wedge in that order, represented a challenge to that order. And therefore, and to understand the creation of those communities, the law of slavery was simply useless to understand that. That was not really what was going to provide the answer. So we had to reorient our research mid-course. I mean, we realized that our original working hypothesis was simply, was wrong. So we were surprised. And I think one of the great things about doing research, and I always tell this to my students, is you've got to keep yourself vulnerable to surprises. You know, allow yourself the opportunity to, when things don't make sense, you have reached a good point. That's because you need to now rethink everything that you had kind of brought into the project and say, wait a second, something is not working out here. So it was not a straight or linear process by any means.
Thank you so much. Barbara's comment is that that's fascinating information. I'm going to follow this up with a question from Isabel Altamirano, who asks another question about methods. The question is about the archives in Havana. When I was working in the New Orleans Notarial Archives, Dr. Rebecca Scott told me that the archives in Havana did not have the necessary equipment to protect the documents. Has the situation changed in recent years?
Unfortunately, the answer to your good question, Isabel, is no, it hasn't changed. Cuba has the notarial archives of Havana start in 1578. There is only one notary that between, in the late 16th century and early 17th century that exists at this point. There were 4 in the city at the time, but only one of those archives exists. Those documents are falling apart. Yet the social history of Havana is in those documents, including absolutely fascinating glimpses into the social history and the social existence of Africans and people of African descent, but including Africans. I'll tell you an example. In 1601, we didn't use this in the book. I found something that I had never seen before. I was very young then, and I spent countless hours at the National Archives in Havana. Probably the happiest period in my life. I would just spend my whole day there. One in the notarial records since 1601, one African woman, Ana Biojo. Ana is her Christian name. She probably had another name. From the Biojo would indicate that she came from the Bisagos Islands, somewhere around Cape Verde, Senegambia Rivers region. She actually, an enslaved woman, African enslaved woman, dictated a will. And there is a register of that will in the notarial. Now, that's simply unique, the opportunity to get a little window into this woman's subjectivities and concerns before death, to get a piece of her existence as a social subject, beyond slavery or beyond, slave is a label, it's a category, but here you get in these documents little pieces like this that really give you an opportunity, a unique opportunity to study the actions and the dreams and the families and the networks of subaltern actors, including many people, many Africans, including enslaved people, which is, to me, is absolutely fascinating. But those documents are in bad shape, and it will require significant resources to restore them. I know that the Cuban National Archives have taken some steps to do this, but but the answer is that at this point, the existence of those documents is seriously compromised.
Thank you for that. Are there any other questions? I'm combing the Q&A in the chat to make sure that everybody's had a chance to ask questions. Okay. Well, seeing none, I know it's going to be, I know you can't see this, Dr. De La Fuente, but we do want to thank you very much for a fascinating talk. We really appreciate your being here today. And we want to thank all the attendees for coming. And as you see, I've shared my screen. I just want to make sure to invite you back next week. Our next speaker is going to be Dr. Davin Phoenix from the University of California, Irvine, and he's going to be talking about anger, race, and emotions and how that affects political behavior. So with that, I will thank you again for coming today, and we look forward to seeing you next week. Take care.
Thank you, Andrea. Thank you all. Thank you for the opportunity.
Oh, my pleasure.
Bye-bye.